Right. Good morning, everyone. I'm Kathleen Warshawski with Seniors Blue Book, and you're at the Elder Law Boot Camp. We're going to talk about benefits available for veterans and their families today. Today's program has been hosted by Seniors Blue Book, McNair Dallas Law, WellMed's Caregiver SOS program. I'm going to ask Miss Letitia to come on the call and tell us a little bit about the WellMed Caregiver SOS program. Letitia, are you there?
Yes, I am. Good afternoon. Good afternoon, and thank you for joining us today. My name is Leticia Guzman Sanchez. I'm a Regional Operations Manager for the WellMed Charitable Foundation. It's great to be here, and again, thank you for joining us today. The WellMed Charitable Foundation was established in 2006 by Dr. George Rapier. We support senior adults and their family caregivers in our community. The foundation has grown to become one of the leaders in the country for caregiver services. One of our signature programs is a Caregiver SOS program. We offer support to family caregivers on their caregiver journey. This program is about individual caregiver coaching, information, access to resources in our communities, support and education for the family caregivers. We have a team of caring caregiver specialists, some in person and some, we have one telephone caregiver specialist that services caregivers outside our senior centers. This team of caregiver specialists help family caregivers and their friends who are caring for loved ones afflicted by Alzheimer's disease, dementia, or other chronic illnesses such as stroke, cancer, diabetes, chronic lung disease, that's just some of our chronic illnesses. But essentially, the caregiver specialists connect with the family caregivers and they start the process, the journey of how can we help them. And we do that through individual caregiver coaching. I want to talk to you very little about one of our services, which is available over the phone, and this is the Caregiver Teleconnection. This is a free 1-hour session where we have speakers that talk about issues that are very important to family caregivers. So we might have social workers, physicians, attorneys, any topic relevant to the caregivers. These hour sessions are available over the phone. Again, they last 1 hour, and there's always opportunity for caregivers to ask questions at the end of the sessions. We have another signature program, which is evidence-based, and this is a stress-busting program for family caregivers. The caregivers meet for 9 weeks, and in these sessions, they learn about how to manage their stress levels and acquire coping mechanisms. In each session, the caregivers also learn and practice a stress management technique. We have 2 platforms for these stress-busting programs. One is for Alzheimer's and related dementias, and the other one is for any other type of chronic illness. So I would like to invite everyone on this call to please visit our website, which is WellMed, the WellMedCharitable.org. And here you can find all the resources that we provide, including our senior centers. But in this website, if you go under Caregiver SOS, you will find also a newsletter that is available for those of you that might want to register. We are planning our upcoming summit in November, so you can also get yourself on that list to receive the invitations. And we also have a weekly radio show for family caregivers. We also have a Facebook page. So again, it's a pleasure to be here, and I hope that everyone enjoys the program. Thank you.
Thank you, Letitia, for that great explanation. Our next host today is Seniors Blue Book. I'm Kathleen, and I represent Seniors Blue Book. Seniors Blue Book is filled with caregiving resources. We have our resource guide, which is a print edition as well as available online. We have our discharge planner resource notebook. It's great for our discharge planners and care managers, social workers at hospitals, skilled nursing, assisted livings. It's available for all of you. And then you can also search for all of these things online at seniorsbluebook.com or sbbdallas.com. And if you need more information, please see me. If you need books, just send me an email and I'm happy to get those for you as well. And lastly, our last host is McNair Dallas Law. And you're going to hear a lot more from them in just a little bit. And we're so grateful that JOHN MCNAIR is joining us today. The purpose of this educational activity is to increase the knowledge of the healthcare professional about financial assistance available to veterans and their families to increase support for the aging community. For those of you on the call who are going to need continuing educational credits, I just want to let you know that you do need to register via Zoom with an email address. You need to participate in the Q&A discussion, and you need to attend the entire presentation. You will also need to complete an evaluation at the end of the program. You will have 24 hours to complete it, and then it will be closed, so make sure that you do that. You'll receive 1 contact hour for social workers and LPCs, and then your certificates will be sent via email somewhere in the next 2 to 3 weeks. There are no relevant financial relationships that pertain to today's program. There's no commercial support. And as we have discussed already, it's been hosted by WellMed Charitable Foundation, McNair Dallas Law, and SBB University. The continuing education credit is provided by Seniors Blue Book. And with that, I will ask JOHN MCNAIR to prepare to take over. I just want to quickly introduce John. He has been practicing law in Texas since 1984. After building a successful estate planning practice in the Dallas area, he applied his legal and financial expertise to clients in need of health care, focusing on Medicaid planning, VA pension qualifications, and other elder law issues. He earned the National Elder Law Foundation Esteemed Certified Elder Law Attorney designation in 2016. He's also earned a Master of Tax Law degree from SMU and received his Doctor of Jurisprudence degree from the University of Arkansas. He's a board certified tax law, estate planning, and probate attorney, as well as a certified public accountant. He's also an accredited attorney with the Veterans Administration. He has so many more things that he does, and I'll let him tell you about some of those himself. So with that, I'd like to introduce JOHN MCNAIR.
Thanks, Kathleen, and thanks everyone for attending today. And so Kathleen, if you'll go ahead and move us forward and forward and forward. You've already given them these, right? Well,
no, I let you do them.
Okay, so for those who are getting credit, hopefully you'll be able to list general criteria for receiving the VA pension. You'll be able to describe the VA pension categories and be able to identify credible and appropriate professionals to assist with VA planning. Okay. Don't worry about writing everything down. We've got a guide that we provide. Hopefully, I'm pretty sure that Susan has provided that to Kathleen and will be available to participants. It's a quick summary of some of these rules that will help you remember some of the things that I talk about today. Next. Okay, what is the need here? Why do we need to talk about this? There's a huge need for long-term care services in the United States. More than 10,000 Americans will turn 65 every day through the year 2029. At least half of all older adults will need personal care assistance. 1 in 3 people turning 65 will require care in a nursing home at some point in their lives. Assisted living, memory care, and nursing home can exceed $5,000 to $10,000 per month. All pretty scary when you're worried about finances. And let me take a moment to talk about another program that is important because you have to understand VA in a larger context. There's 2 programs that we try to look at, 2 government programs we try to look at for seniors to provide financing for long-term care. if the senior is not just simply self-financing or has a long-term care policy. And that is Medicaid and VA benefits, the VA pension benefit that we'll talk about today. The problem with Medicaid is this. I look at care for seniors as being in 3 phases. Usually it starts off with somebody receiving in-home care. They're in-home caregivers, either family members or professional caregivers. Eventually, they may need to go into assisted living or memory care. And later, as the needs grow, they may ultimately need to go into skilled nursing. Medicaid was created by Congress to be an entitlement program. What does that mean? Entitlement means that if you meet the criteria, the financial and medical criteria to qualify to receive Medicaid for long-term care services, if the state of Texas wants to participate in that program, they must provide money for those services. However, that entitlement program is limited to care in a skilled nursing setting. If you are in a skilled nursing setting, the entitlement portion of the program kicks in, and you will be covered if you meet the financial and medical criteria. It is not an entitlement program at any level of care less extensive than skilled nursing. So the federal government left to the states to decide how much they wanted to fund and finance more generous services at the assisted living, memory care, and in-home care level of care. The state of Texas has chosen to underfund those programs. So if you want in-home care, you're going to need to get on an interest list. There's an 800 number you can call that's listed on the Texas Health and Human Services Commission website. And it will be 1 year to 2 years before you get up to the top of that list. And you need to be financially and medically qualified once you get up to the top of that list. That program in Texas is called Star Plus Waiver. So if you want to be on the Star Plus Waiver program to obtain in-home care services, you're going to have to wait a while, 1 year to 2 years. And because they're underfunded, the state of Texas is not providing a lot of money for assisted living and memory care communities. And so most of them do not have Medicaid beds. There are a few skilled nursing communities now that are completely private pay, but most of them are going to be both private pay and Medicaid financed. It is extremely rare to find Medicaid beds available in North Texas for memory care or assisted living. That's why I love the VA pension program, because it provides care it provides money for care no matter where you are. Now, the big difference between Medicaid and the VA pension program that we're going to talk about today is in the amount of money. If you're in skilled nursing and Medicaid pays for it, they're going to pay for 100% of that bed. Well, 100% other than your income. Your Social Security and private pension will pay for your Medicaid bed, and the state of Texas will pick up the rest of the cost of that bed. The VA amount is a specified dollar figure. It is not going to be enough to pay 100% of your care at home or your care in assisted living or memory care. But it is available at assisted living or memory care or in-home level of care, whereas Medicaid may not be available at all. So what I tell clients is that the VA benefits are going to help you stretch your assets, stretch your money out for a longer period of time. It's going to be a supplement on top of everything else that you may have, your own assets, plus your Social Security, plus your private pension. So it is a very useful program, as we will discuss. All right, let's go forward. So there's two cash benefit programs in the VA system. One is what the VA calls compensation, which is service-connected injuries. And when I say connected, it just means that you were injured while you were while you were actively participating in a service-related activity. I'm not sure that they would cover you if you, I don't know anything about this program. I don't know if they would cover you if you were in a car wreck off of the base and had nothing to do with your service. But if you have a service-related injury, they will pay you X% of your disability. And that's, 10%, 50% disabled, 100% disabled. They will make a determination. And veterans and specialized attorneys will fight with the VA about getting that rating as high as possible. That is not the program that we are talking about here today. This is the pension program, which is a specialized program to provide dollars specifically for long-term care. So, John, what happens if somebody's potentially dual? Oh, not yet. Eligible for both programs. What if they were receiving compensation and now they need long-term care services? Well, the VA has an answer for that. You get the larger of the two benefits. You can't get both. If you were injured while you were in service and you've been receiving several hundred, let's say $750 a month for many years, and then all of a sudden you need to go into assisted living and you can prove that you meet all the criteria to qualify for the pension program, or what is sometimes called the aid and attendance program, then you will qualify for the higher of the two, because the pension program would pay more than $750 a month. We'll get to the numbers in a minute. There are 3 levels of benefit in the pension program. There's basic, there's the basic level, there's the housebound level, and there's the aid and attendance level. That's why this program is sometimes called aid and attendance. I have been doing this for quite a number of years now, and I have never tried to qualify anybody for anything other than aid and attendance. Everybody always goes for the maximum. And if I have a client, we're always going to go for the maximum, and we're not going to apply until we really qualify for the maximum. It's easy to do. I mean, it's not that difficult to differentiate being in the aid and attendance category from housebound. So really, for our purposes, we're all going to talk about the aid and attendance program here. When you qualify, they will ask you for your account and routing number. That's on the application for your bank account, and they will make a direct deposit into your account every month. So they don't send checks through the mail. They just directly deposit it to your account. There's a little hiccup in that sometimes, not a hiccup. If you qualify, they're going to start the next month directly paying you that benefit. However, it takes them several months to figure out that you are qualified. Let's assume that I applied in May for a client and the VA didn't get around to figuring out that he was really qualified until October. So that's May, June, July, August, September. That's 6 months worth of benefits that he was entitled to that he hasn't been receiving. The VA is going to write a retroactive check to the veteran for those 6 months and will be deposited into the account. However, when you apply, you have to have it has to be accompanied by a doctor's determination that you have the need for aid and attendance benefits and assistance with activities of daily living. And on that form, they ask the doctor if you are competent to the veteran, are competent to handle your own finances. And oftentimes the doctors will say no, because often the veteran is suffering from some form of dementia at that point. If they say no in the VA system, that means that the VA will not release that retroactive payment until the veteran has a fiduciary appointed for them. And what is a fiduciary? Well, that's some family member that is going to be responsible to the VA to report to them how that money is being spent on the veteran in that account. So it's not really that difficult. It's somewhat similar to a representative payee position for Social Security Administration when there's an incapacitated individual receiving SSI, but that's what it is. So that's the one little wrinkle in receiving the benefits. And by the way, the aid and attendance benefits are not considered taxable income. So that's nice too. All right, next. So there's two types of planning that we're going to talk about today: proactive planning and crisis planning. So proactive is while you're healthy, you don't have any current need for long-term care services, but you may be have too many countable resources under the criteria we're going to talk about to qualify. The other is a crisis plan. You need to get into assisted living or memory care right now, or you need in-home care services right now, and you exceed the net worth limit. So we'll talk about both types of planning. All right. Next. So let's first talk about categorical qualifications. You have to be in certain categories to qualify for this benefit before we talk about financial criteria. You have to have been in active duty for at least 90 days, one of which was during a period of conflict, a declared period of conflict. And I have those dates if you're interested. You don't, again, this is something you don't really need to memorize, but World War II was officially a war from December 7th, 1941 through December 31, 1946. So if you served during that period of time, you were on active duty, hopefully just at least 90 days. Korea was June 27th, 1950 through January 31, 1955. I've encountered quite a few veterans that served their active duty between 1946 and 1950. And unfortunately, they are in that gap period when they don't qualify. The Vietnam War was a declared war from August 5, 1964 through May 7th, 1975. Vietnam is the one exception to the rule that you have to have served during that declared period of conflict. For Vietnam, if you are in country, if you actually went to Vietnam between February 28th, 1961 and August 5th, 1964, even if you weren't, even while it was not a declared war, they will cover you in this program. For every other conflict, you have to have served exactly during those periods where it was a declared conflict. And by the way, other than that exception, you don't have to have served in country. You don't have to have gone overseas. You don't have to have gone to Europe or Asia during World War II. You don't have to have served in Korea. And it's 90 days. Now, if you're a younger veteran, they changed the rules. The Persian Gulf Wars were a declared war starting on August 2nd, 1990, and they continue to be a declared war. It's not been declared ended as of yet. I'm assuming they'll get around to that eventually, since we got out of Afghanistan last year. But for those younger veterans, it's now 24 months of service, not 90 days. So you have to have been in quite a bit longer to qualify under the later rules. Okay, next. Let me back up. Well, okay, I'll get back to surviving spouses. There's another slide coming up about surviving spouses of veterans who can also qualify, but there's other qualification criteria for them. So we'll get back to that. In addition to having served in during the right period of time for the right amount of time, you also need to have the need for assistance with regular aid and attendance, which means that you need to have the need for somebody to assist you with at least 2 of the 5 activities of daily living that the VA considers activities of daily living. I know there are other definitions of that term for long-term care policies, but for the VA purposes, it's bathing, dressing, feeding, toileting, transferring. And when I say feeding, I mean actually feeding you the food. It doesn't mean cooking for you. So things like medication management, house cleaning, transportation, none of that counts unless you're also providing assistance with bathing, dressing, feeding, toileting, transferring, ambulation, etc. And your doctor will have to verify that you need this assistance, either in the assisted living or memory care or at home with in-home caregivers. And by the way, when I say in-home caregivers, that can be a family member. You can have a family caregiver agreement, which I've done on many occasions, where a family member who is providing that care can contract with the senior to provide those services as long as you keep up with it. And the caregiver is willing to have that income be taxable income to them, subject to withholding and all of that. Then you can use that money, because we're going to need expenses, as we'll talk about in a minute, to offset your income in order to qualify here. So the caregiving can be a family member, but there needs to be a contract that we can put in front of the VA to make sure that they believe that it is a valid contractual relationship. Okay, next. I mentioned the surviving spouse. So a surviving spouse can also qualify for these benefits. But to be a surviving spouse, there's 2 things. Number one, you cannot have ever divorced the veteran. And number 2, you can't remarry. So if when you apply, you've never remarried and you didn't divorce that person, then you can be treated as a surviving spouse. One of the interesting things when you apply for VA benefits is that they require that you submit, even if it was a single veteran, they require that you submit information on all of the marriages and divorces of that veteran. And if you're a surviving spouse applying, you have to provide information on all of the marriages and divorces of both the veteran and the surviving spouse. They might have both been divorced earlier and then married to each other, and then that surviving spouse married the veteran until the veteran died and became a surviving spouse. That could happen. They just want to have information on all of that. Okay, next. So income, you can't have too much income. And what is too much income? Income is too much if it exceeds the benefit. And we'll have a slide that tells you what the benefit amounts are right now. But if your recurring Social Security and private pension exceeds the benefit, there's a dollar for dollar reduction of the benefit until it's wiped out if you have too much income. And if you're a married veteran, they look at both your income and your spouse's income. And if that were the end of the story, then nobody would qualify for this benefit. However, your qualified, quote, medical expenses can be used to offset your income. And that's really important. So the cost of your assisted living, the $6,500 that you pay every month to your assisted living community or your memory care community, that can be used to offset the income. They changed the rules in 2018, and the income theoretically can be a problem in two ways. Number one, we just talked about, too much income, you don't qualify. But in calculating if you have too many assets, they also changed the rules. There's a certain amount of countable resources, cash, stocks, bonds, property that you could spend on your own care that the VA sets. If you have assets below that level, you qualify. If you have more than that, the excess means that you don't qualify. After 2018, if you have monthly income, they also annualize that. They multiply that by 12 and they add it to your assets to determine if you're over that amount. So, and for that rule, they also allow you to deduct your medical expenses. So you really don't want to apply until you have medical expenses that exceed your income. And when I say medical, I don't mean doctors and hospitals. I mean assisted living or memory care or in-home care expenses that exceed your income. That's when we apply, once somebody needs that amount of care. I've had many conversations with people about, well, you're not getting enough care. If you want to qualify for this, and you really need more care than you're receiving, then you should probably consider getting more care. All right, next. What is that net worth limit? It changes every year based on inflation. And the VA sort of kind of tied this number to a number that has to do with married couples in the Medicaid arena, but it's slightly different. And I'm not going to go into the reason that it's different, but it's currently in 2022, that amount is $138,072. So what does that mean? That means that if I'm a veteran and I meet all those other criteria that I just talked about, I have expenses in excess of my income, I served during Korea for at least 90 days of active duty, and I have $100,000 of cash in the bank and nothing else other than exempt assets, which I'll talk about in a second, then I qualify for the benefit. Don't have to do anything else. Don't have to hire an attorney, don't have to do anything to help me qualify. I am done. What are exempt assets? I mentioned that phrase. That's an important point because some assets don't count against you. There's a few that are the primary ones. The primary one is your residence. Your residence is an exempt asset. However, the VA is a little different than Medicaid for this purposes. Under Medicaid, there's a dollar figure. If the value of your residence exceeds that dollar figure, it's not an exempt asset for Medicaid. And that amount is this year $636,000. If your residence is less than $636,000 for Medicaid, it's an exempt asset. For VA, they don't care what the value is, as long as it is 2 acres or less. If it is more than 2 acres, it's not an exempt asset. There was a lot of back and forth with the VA in the comments from attorneys all over the country about this rule when this rule came up in 2018. Are you saying that an apartment that you own in New York City worth 20 million that is less than 2 acres is an exempt asset, whereas somebody that owns 50 acres out in East Texas that is $100,000 is not an exempt asset? And the VA said, yes, you are correct, sir. So nothing you can do about it. For rural people, it's a problem, but your residence can't be more than 2 acres. There are other things that are exempt, like your vehicle and burial plans and burial plots, which those are similar rules to Medicaid. Okay, next. I mentioned the benefits that you can get for in 2000, and again, these are adjusted for inflation each year. So this year, in 2022, a single veteran can get $2,051 per month. A married veteran, this is the highest amount that anybody can get in this program, is $2,430 a month. And a surviving spouse, $1,319 per month. As I said, this is not going to cover all of your expenses, but it is going to help stretch your assets out so that they last a lot longer. And these are the numbers that you have to look at when you decide, are my expenses associated with assistance with activities of daily living sufficient that I should apply for the program? Okay, next. All right, I'm not going to use this slide. Let's keep going. Keep going. Keep going. Keep going. Sorry. Keep going. One more. Oh. All right, there's a slide that's not in here that I thought was going to be in, but that's okay. So let me explain some rules about gifting to qualify. Prior to 2018, let's back up a few slides, Kathleen. Keep going. Okay, let's just leave it there for right now. So prior to 2018, you couldn't have too many assets. That there wasn't a hard and fast number like 138,000. And they didn't tell you what it was, but there were no penalties for making gifts. In 2018, the rules were changed, and now there's a penalty for making gifts. And that gift is the amount of the property gifted divided by the maximum amount that a married person can get in the way of benefits, $2,431. That gives you the number of months of penalty, the number of months you will not qualify. However, it's not all property that's gifted that it creates a penalty. It's only gifts of, quote, covered assets. What are covered assets? Covered assets are those assets in excess of $138,000, non-exempt assets. So if I have $200,000 of cash and I give 200 minus 138,000 to my daughter, Sarah, I've created a penalty for that amount of money divided by $2,431. That's the number of months that I will not qualify. So we don't really want to do that. We don't want to make gifts and then apply. That's not going to be a smart move. There's also a rule started in 2018 that there's a look back period. You may have heard about look back periods associated with Medicaid. That's a period of time in which you have to report gifts. So if you apply in May of 2022 for VA benefits, you're going to have to report all gifts made back through May of 2019, the last 3 years. And if you have any that you have to report, they will create those penalties. We don't want that to happen. So nowadays, we have proactive planning, which we talked about at the beginning, and we have crisis planning. Let's say you have $300,000 or $400,000 of assets, and you feel like that are countable, and you feel like you don't really need all of those. You have sufficient income, and you could keep maybe $100,000 of countable resources in your name, and you're willing to gift the rest. You could gift it into an irrevocable trust for your children. Why would we use a trust, John? Well, we would use a trust because everybody in the family thinks of that trust, that irrevocable trust, as kind of a bank for mom and dad. It's irrevocably gifted so that the benefits are solely for the kids, but if there's an emergency and mom and dad need more of that money, the kids can always pull it out and re-gift money to mom and dad. But if you give money outright to the kids, bad things may happen to them. They may die, they may become incapacitated, they may get divorced, they may have creditor problems associated with the business, they may be in a car wreck and somebody sues them and gets a judgment against them. All of these things put mom and dad's money at risk. Whereas if it's in an irrevocable trust for the children, we have eliminated those risks. Let me get down in the weeds just a bit for you about the way these trusts would be structured. There are two types of trusts for income tax purposes. Grantor trust, where all of the income is taxed to the grantors, and non-grantor trust, where the tax is either to the trust or to the beneficiaries. We want this trust to be the latter when it's a VA trust, because we don't want to have to explain to the VA why is income being taxed to the veteran when he's not a beneficiary. It's hard to explain that that's really not a trust for his benefit. So we don't do that. We make the income taxable either to the trust or to the beneficiaries, not to the grantor when we're giving cash. Now, let's talk about another technique that is often used with these irrevocable trusts. A lot of people these days have less than $138,000 and they're ready to apply, but they have a $200,000 or $300,000 or $400,000 house that's exempt, and they could have that house sit there forever and continue to qualify for these VA benefits. But what happens if the family doesn't know a smart elder law attorney that explains to them, you know, if you apply for VA benefits for your dad because your dad qualifies right now, but 6 months later you realize his Social Security and his VA pension is not enough to pay for his care, we're going to need to sell his $300,000 house. Guess what? Dad's not qualified anymore. You just gave him $300,000 of cash when he used to have a $300,000 exempt asset. That's bad planning. So what do we do instead? We create what I will call a two-lung trust. One part owns his house. He gives his house into the trust. He retains the right to live there. He retains the right to benefit from it completely. And that part of the trust is a grantor trust, because if it's ever sold, we want the capital gains to be exempt, just like it would be when you sell your house. Up to $250,000 of your capital gain is exempt from taxation if you're single, and $500,000 if you're married. But once it's sold, it goes over into an irrevocable non-grantor trust for the children. And therefore, you can sell the house, have the money available to supplement by regifting money to dad if you need to. But the sale of that house will not create a problem for dad after he's qualified for VA. That is another very common technique. Let's assume for the moment that somebody has qualified and they are receiving those benefits, and then you sell the house. You don't want to make those re-gifting to them real regular, because it's going to look like gifts to the VA. The VA doesn't do annual audits like Medicaid does, but they could randomly check. And if you have those funds coming back from the kids every single month, that's going to look like it's income to the VA, and we don't want that. So hopefully that doesn't happen, that the kids are giving it to them on a real regular basis. They just give it back to them periodically. Okay, talked about the house. Oh, let's talk about crisis planning. So you have more than $138,000. What can you do about that problem? Well, lost the slides.
I'm pulling up the slides that you want, so you keep talking.
Okay. So if you have the excess of 138,000, there's some slides in there about a half a loaf strategy. That's not something that I really use much these days. But there's a couple of other techniques that we sometimes use. Oftentimes, the parents will move into a house with the children, and the children will provide, or they're in caregivers will come in, professional caregivers will come in to provide for mom and dad. One way to use those excess funds is to actually purchase an interest in the children's house. I've done that a few times. You don't have to have 100% ownership. You just have to live there and have some percentage ownership, and it's a residence. So that's a thing. I have not done this. It seems aggressive to me, but when the regulations were changed, the VA never tightened down their language about what's a residence. And one thing they never said is they never mentioned that you have to have occupied that residence prior to applying or ever. And they never mentioned that you couldn't rent the property. So theoretically, you could, if you don't have a residence, you could purchase a $300,000 or $400,000 residence that you never lived in. You could rent it and you could apply. So there's that. Maybe most people are not that far over and they want to just use excess funds to buy other exempt assets like vehicles. You can buy vehicles for not only yourself, but everybody else in the household. So if mom and dad live with the kids, they could buy cars for the son and daughter-in-law. And they could buy, here we go. They could buy let's see, burial plots and cars for everybody in the family as well. Let me see, let me think. We talked about the non-grantor trust, the gift to the residents. Talked about the caregiver agreement earlier and the purchase and the interest in the child's residence. So I think that I have maybe 8 minutes left. Is that right, Kathleen?
Sorry, I have to unmute. Yes, you have a full 8 minutes left.
Okay, let's go through the last slides really quickly. Okay. Oh, yes, here's the, nope, let's back up. In 2018, the VA created a problem, and I have never seen a very good solution to this problem. Your retirement accounts are countable resources. It used to be, prior to 2018, that you could put your money in those IRAs in something called an irrevocable immediate annuity. That's a contract with an insurance company that says, here's my $300,000 of cash that I had in my IRA. Will you please promise to pay me $3,000 a month for the next number of years? Assuming you have expenses in excess of $3,000, that works like a charm. Medical expenses in excess of $300,000 because it was no longer a countable resource because you couldn't get to the $300,000. It was irrevocably with the insurance company. In 2018, the VA changed the rules and said that's a penalized gift if you do that. Period. End of discussion. We don't care what you call it. We're going to call it a gift, and it will create a problem for you. After 3 years, it will no longer count against you. I have had a client with this situation currently. The problem is all of that extra income has to be added to your other sources of income, and you have to have really high medical expenses to overcome that. So unless you just pull the money out of a really large IRA, subject yourself to income tax, and then do other planning techniques that we've already talked about, that's a very difficult problem. The IRAs are just a tough nut to crack. So just wanted to mention that one. Okay, continuing. There are a lot of entities out there that will say that we will do all of this VA planning for free. What they are typically trying to do is to get you to invest money with them so that they can sell you annuities. You really want to deal with only accredited attorneys like myself, VA accredited. There are also accredited agents. These are non-attorneys that have gone through training and testing to prove that they understand these rules. That's fine to go to an accredited agent. And there are VA entities like the every county has a VA office with volunteers that will do this for free. So, and I have referred many people to the Dallas County office, and those kind of entities work fine as well. Always go to somebody that has one of those criteria. Don't go to one of these types of entities that are going to try to sell you something. Next. Yes, no, these are not good entities. Keep going. Same thing. Keep going. All right, that's it. I'm not going to talk about Medicaid. So I'm going to open it up to questions in the last few minutes that we have left.
Susan, would you like to help moderate the questions? Are you there? Let me go into the chat. So if someone has a question, you can raise your hand or you can type it in the chat, and typing it in the chat will be the easiest way for us to assist you with your questions. And I know that there's a lot of comments here, so just give me a moment to find it here.
There was one about
Renting. There's something
asking about renting, yes. does the, if that was your question, I guess you could clarify, but does that mean, we were talking about how if you're in assisted living, you can offset the cost of the assisted living care. So I don't know if they're talking about renting us in an assisted living community or memory care, or if,
So if you live in assisted living, you have to first prove that part of what the assisted living community is doing for you is providing some of that money is going for directly for assistance with activities of daily living. Once you prove that, the room and board that they charge you in addition will also be a deductible medical expense that you can use to offset income. That's how that works. That's why, I don't know, in-home care is really expensive. And if you use a lot of it, it's going to be really expensive, but you don't have that room and board thing like you do with assisted living or memory care that you can add on to the cost of the assistance with activities of daily living. If you're at home and receiving in-home care, it's just the cost of that caregiving. There's no other room and board that you can add to it like you could if you were in assisted living or memory care.
great, thank you. There was a question from Rachel asking, could you re-explain the part about the penalty for making gifts?
So the penalty for making gifts is when you give covered assets. That is anything that's not an exempt asset. So you can give exempt assets. That's why in my example of giving a house into an irrevocable trust is perfectly fine because it's an exempt asset. You can give anything less than 138,000 and you can give exempt assets without penalty. But if you had assets in excess of 138,000, all of the cash, stocks, bonds that you gave in excess of 138,000 would create a penalty, and that the number of months of penalty, the period of time you are not eligible for your VA benefits, would be calculated by dividing that amount of gift of covered assets by $2,431.
And these numbers will be on we have a one-page guide to VA pension, and actually a one-page guide to Medicaid, nursing home Medicaid as well, that will be sent out after you complete the evaluations. Then when we're sending out the certificates, we'll make those available to everyone.
So there's a question, if you purchased a $200,000 annuity, which pays out $900 a month, is the $900 a month counted as income? Is the full $200,000 counted as an asset? Investing in the $200,000 immediate annuity will be treated as if you made a $200,000 gift. You will create a $200,000 penalty. A $200,000 divided by $2,431 monthly penalty. I don't know how many months that is, but it's going to be a long time. And the $900 would be additional income to you. So it's a really bad strategy. It's not something we would ever do.
Someone else asked, unsure if
Oh, is there an age limit for qualifying for VA pension? Somebody mentioned. So it has to do with you being medically qualified. If you're over 65, they assume you're incapacitated. You don't have to prove incapacity. So having reached age 65 in October of last year, I take some umbrage with that, but be that as it may, the VA would treat me as disabled and I wouldn't have to do any additional proof. There would be additional proof if I was under 65. That's how it works as far as age limits.
someone else
The
is,
other age related is the fact that it's 24 months for younger veterans that served in later wars.
Edith is asking, the VA pays for in-home care for attendant care, not homemaker services. Is that correct?
They pay for in-home assistance with activities of daily living. If you prove that that caregiving company is providing that care, they will pay for that. I'm sorry, you will qualify if those expenses, including the other expenses, are they breaking it out in their invoice as far as how much of their hourly rate? It's usually not broken out. It's just $20 or $25 an hour. And then you have them fill out a form that says, also, we're doing the following things for them. That you don't have to break it out and show that some of the money, the $20 per hour, is going for cooking. You just have to prove that you are providing assistance with bathing, dressing, toileting, feeding, in addition to the cooking. If that makes sense.
Thank you.
If it was only the cooking, no, you wouldn't be able to do it. Other question? I thought I saw one.
There are a couple other questions. Someone was asking about, in order to receive these benefits, the veteran has to be registered in the VA system. And so what does that entail?
Well, when you apply, you're going to have to give them a certified copy of your discharge papers, mostly your DD 214. And that proves that you were a veteran that served at least 90 days, one of which of active duty, one of which was during that period of conflict. You will have your service number, etc. So yes, you have to prove that with your discharge papers.
Someone asked, is this all handled in the same office that determines VA benefits?
I'm sorry, is what?
Is VA pension handled in the same office that determines VA benefits? So I'm wondering if they mean compensation, or whether or
No,
not the
yeah,
veteran
there's
gets
different, they have different,
prescriptions or things like that.
right, yeah. The people that handle service-related injuries are different than the VA section that deals with pension. There's a specialized section that deals just with pension activity. And for Texas, you file your applications at their office in Janesville, Wisconsin, wherever that is.
But the departments do seem pretty siloed.
Yes, that's right.
Someone asked, when you say penalty, this is in time, not in real dollars.
It's in time, a period of time in which they are not going to give you dollars.
Right. Someone else asked, the VA pays for in-home care for attendant care, not homemaker services, correct? I think you may have addressed that.
I already covered
Depends on
that.
if the bill is itemized, right? So
The bill's never itemized. They're just charging per hour. And they fill out a form that says we're providing these assistance with these activities of daily living to this senior, in addition to whatever else we may be doing.
there was another question about annuities. Is there a 3-year limit when the gift and income become non-countable?
So if you annuitize something and you wait 3 years, the annuitization that created a gift, you no longer have to report that gift. You don't longer have to report that annuitization so that it won't be treated as a gift because you're beyond the 3-year look back period. However, you have created an additional source of income, and you really have to look hard at whether you have enough medical expenses to overcome that income, plus your Social Security, plus your private pension from when you were employed, et cetera, et cetera. that may be difficult to do, but right, the penalty goes away after 3 years because you don't have to report that annuitization anymore. It'll be obvious because you will be receiving that income and you'll have to give them a copy of the contract, and the contract will show that you purchased it more than 3 years ago.
Okay, so somebody asks, is the county veteran service officer the best place to start? That's a great place to start. They can be very busy. So it can help to get an email address for them and follow up with the email address with a phone call or vice versa. And then another question asked about reverse mortgage. I don't know, that might be a whole nother presentation.
Well, a reverse mortgage is not an asset, but if you utilize a reverse mortgage and you have money, then you have to look at the money you got and did you get more than $138,000 out of it? And then if you did, everything else over and above 138,000 is a countable resource. That means that you're not qualified. Having a line of credit is not an asset.
Right.
Using a line of credit creates cash, which is an asset.
And I think one last question asks about a mobile home. Does that come under the same criteria as real property?
Yes. A mobile home on top of a lot's even better.
As long as it's not more than 2 acres.
As long as it's not more than 2 acres.
Thank you.
Put a mobile home on top of a lot in downtown Manhattan and call it your home.
Wonderful. Well, I think that's all the time we have for questions. I want to thank you so much, JOHN MCNAIR and Susan Rogers, for being here to put on this great presentation for us and answering all of our wonderful questions. I want to thank Letitia Guzman from the Caregiver SOS program with WellMed Charitable Foundations for helping host today's program. And I want to thank Seniors Blue Book and SBB University as well. Here's your reminder to complete the evaluation. There is a QR code on the screen. If you would like to use your phone to scan that QR code, you can do it on your phone while you're saying goodbye to us. You can also, I have also put the link in the chat about 3 times now. So you can also complete it by clicking on the link in the chat. If you are still unable to access it, please email me in the next 10 minutes at Kathleen@seniorsbluebook.com, and I will be happy to email you a link to it as well. So thank you all for being here today. We appreciate it. We look forward to hosting more programs and having you attend those as well. Have a great day.
Thank you, everyone.
And I'll stay on for just a few minutes.